Mr. Castleberry, you are ready to proceed with Mr. Travis. Okay, we are on record in file number 23-21380-FH, People versus Tyler Lee Travis. We are here today for an arraignment in this matter. We are proceeding today in person and by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Fleming for the people.
Christopher Fleming, appearing on behalf of the people.
Bert Castleberry, on behalf of Mr. Travis.
All right, Mr. Castleberry, does Mr. Travis wish to have the information read this morning?
He does not, Your Honor.
Have you received the prosecutor's witness list and request for discovery?
I have, Your Honor.
And how does Mr. Travis wish to proceed today?
We would like, he pleads not guilty, and we would ask for a pretrial.
Court will enter a not guilty plea for Mr. Travis and set a pretrial for July 26th at 8:15 a.m.
Thank you, Your Honor.
Anything else to address today, either Mr. Fleming or Mr. Castleberry?
Nothing for the
Your
people.
Okay, thank you very much.
Thank you.
Okay, Mr. Murphy, what cases do you have this morning?
Warren, Your Honor, I have Nathan Hernandez.
One second. All right, I have someone here from MDOC, and I can't see the person on the screen. Can you tell me who you are?
Andrew Cecil here.
Okay, sorry.
Can I have a breakout room with him?
You can. Give me just one moment.
Thank you.
Okay, Mr. Daly, are you ready to proceed with Ms. Nolan?
Yes, Your Honor.
Okay, we are on the record then in file 23-21334-FH, People versus Kelsey Carol Nolan. We are here today for a pretrial conference. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Fleming.
Christopher Fleming, appearing on behalf of the people.
James Daly, appearing on behalf of the defendant.
Okay, Mr. Daly, where do we stand with Ms. Nolan's case today?
Ms. Nolan is charged with both drunk driving and the charge of smuggling contraband. We are prepared today. If she's still able to plead guilty to impaired driving, she'll plead guilty to that, but we're going to set the smuggling charge for trial. That's
Okay,
all.
I only have one file that is the furnishing contraband file. Is there another file or?
The drunk driving confused me.
Oh, I'm sorry. No, I misspoke.
Okay.
So we've got count 2 is the operating while intoxicated. So,
Right.
And I'm sorry. So Mr. Fleming, is there an offer on this case or do we need to set it for trial?
There was a global resolution to a use with 7411 and operating while visibly impaired.
Yeah, that's the global resolution. She hasn't taken all of that yet, so I guess we just set it for trial right now then, Judge.
All right. How many days do we need for a trial?
1 day.
1 day sounds about right, Judge.
All right, Ms. McGreen, could you find us a 1-day jury trial date, please?
Yes. Our first available would be Wednesday, September 20th.
That's fine.
Works for the people.
December 20th, that would be 10:30 for the start time.
September 20th, Judge.
Sorry, thought that's what I said, but okay, September 20th. And let's do a final pretrial on September 13th at 8:15 a.m.
Perfect. Thank you, Judge.
Okay, the court will issue a scheduling order with those dates in it.
Thank you, Your Honor.
Thank you, Ms. Nolan. You can go ahead and log out.
Thank you, Your Honor.
All right, I have a device logged in from the Lenawee County Jail. The microphone is muted and the camera is off. Okay. You are Mr. Hernandez?
Yes.
Mr. Murphy, do you need a breakout session?
Please, Your Honor.
Mr. Noe, you are here for Ms. Coles.
That is correct, Trevor. She is actually in my office with me, logged in on a separate device.
Okay.
We are ready on her.
All right. I don't think at this point I have the prosecutor that we need. So as soon as we have everybody, we'll take care of it.
Okay, thank you. I'm also here on Mr. Vasquez as well, but he is in custody.
Okay. All right, Mr. McCready, what cases are you here for today?
I'm on Malik Owens and Marquise Hernandez. And I'm standing in on two others. That would be Coles and McKenzie.
And Mr. Glazier, what case are you here for?
I'm here on David Taylor.
Okay. All right, Mr. Murphy, are you ready to proceed with Mr. Hernandez?
Yes, Your Honor.
Okay, we are on the record then in file 22-20878-FC, 19-19402-FH, 21-20357-FH, 21-20358-FH, and 22. Okay, so let me start over. We are on the record in People versus Marquise Hernandez, file number 17-18318-FH, 19-19404-FH, and 22-20877-FH. Let me ask people, attorneys to place their appearance on the record, beginning with Mr. Fleming.
Judge, I believe this is Nathan Hernandez.
I put Powell.
I'm really sorry.
Yeah, please, the covered in jail.
Okay. All right, so this is People versus Nathan Robert Hernandez. Files 19-19402-FH, 21-20357-FH, 21-20358-FH, and 22-20890-FH. We are here today for pretrials in all of these cases. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Fleming.
Chris Fleming, appearing on behalf of the people.
Matthew Murphy, appearing on behalf of Nathan Hernandez.
All right, and Mr. Murphy, where do we stand with Mr. Hernandez's cases today?
Your Honor, if you recall, we had a motion, a defense motion that Your Honor granted in regards to a motion to quash the bind over. I think there was some issue with that order getting signed. I think it was sent without the approval signature of Mr. Fleming. So I'm not sure the status of that, if it's been signed and when that's going to be scheduled down in district court. Obviously, these are tailed. I mean, it's directly tied to that domestic violence charge. So at this point, all I can do is ask to either set this for another pretrial, or I mean, if Your Honor is inclined, we could set everything, I guess, for hearing and trial. But again, I think need to find out when that domestic violence is being rescheduled down in district court.
So when I looked at the register of actions yesterday, the order did get submitted under the 7-day rule, and I think that the 7 days expires either today or tomorrow. So I can't sign the order now unless you, I mean, if you prepared one and both signed it and want to send it over, I can sign it today, but otherwise I've got to wait till that 7 days expires.
Well, I'll be prepared and have it sent over today.
All right, and then district court will schedule it as soon as I sign your order. But at the moment, I procedurally can't sign that 7-day order right now.
Okay. I'll resubmit it, Your Honor, today.
Okay, so I don't see really any sense in scheduling another pretrial right now. If it's going to be remanded for a preliminary exam, we'll just set it for another pretrial once if it comes back up. We'll set it for a pretrial at that time.
I believe only one of the 4 files is being sent back downstairs, judges, the DV file, the 20890.
Yes, Your Honor, that's what I was referring to as the
Yeah.
the probation violation.
Good point. So we'll set the others for pretrial. Let's go with July 19th at 8:15.
Thank you, Your Honor.
Thank you, Judge. Mr.
Okay,
Murphy, if you send me it over in order to sign, I will probably sign that.
Yeah, I don't know what happened with that. We got it rejected back from circuit court. So I'm not sure why it was rejected back. So we'll get that done.
All right, and then
We'll go ahead and my office will prepare the stipulation order for that July 19th date for the next pretrial.
Okay. All right, thank you then. If there's nothing else, then Mr. Hernandez, you can let the officer that's with you know that you are done with court for today.
All right. Thank you, Judge.
Thank you, Mr. Hernandez. Thank you, Your Honor.
Let's see.
Judge, on mine, on Ms. Cowles, I did talk to Mr. Sneed. He said Mr. McCready can cover that for him, so we are ready on that one.
Okay, we are on the record in file 22-20978-FH, People versus Rook and Cowles. We are here today for a pretrial conference, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the People, standing in for APA Isaac Sneed.
And Mr. Noe.
Good morning, Your Honor. Charles Noe appearing on behalf of and with the defendant, Ms. Cowles.
All right, Mr. Noe, where do we stand with Ms. Cowles' case today?
Yes, Judge, at this time, we are going to be moving forward with the plea in this matter. Judge, in this case, my client has been offered to plead to count 2 of the amended information, lying to a peace officer, which is a 1-year misdemeanor. In addition to that, there's a kilobruise agreement between myself and the prosecutor's office for no upfront jail.
All right, so that's a plea to count 2, count 1 being dismissed, and a kilobrew agreement to no upfront jail. Mr. McCready, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
All right. Ms. Cowles, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Brooke Ann Cowles.
Yes.
Ms. Cowles, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, lying to a police officer in a 1 to 4 year crime investigation?
Yes, Your Honor.
Are you satisfied with Mr. Noe and the advice that he's giving you?
Yes, Your Honor.
Do you understand that the maximum penalty for this offense is up to 1 year in jail and or a $2,500 fine?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Mr. McCready?
Correct, Your Honor.
Mr. Noe?
Correct, Your Honor.
Is that also your understanding, Ms. Cowles?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Cowles, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial? I need you to say yes.
Yes, sir.
Sorry, Judge, I was muted. That's my mistake.
Okay. Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, a conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
And do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about June 3rd, 2022 in the city of Adrian, county of Lenawee, that you did commit the offense of lying to a police officer in a 1 to 4 year crime investigation?
Guilty.
Has anyone made any threats or promises to induce you to plead guilty to that charge?
No.
You understand that if I accept your plea, you will be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
Yes.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Cowles to plead guilty?
No. Oh, sorry.
No, Your Honor.
Mr. McCready?
No, Your Honor.
Ms. Cowles, other than as we've discussed on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
All right, Mr. Noy, would you like to establish the factual basis?
My pleasure, Your Honor. Ms. Cowles, is it true that you were in the city of Adrian, county of Lenawee, state of Michigan, on or about June 3rd of 2022?
Yeah.
And after that time, did you make contact with a city of Adrian police officer?
Yeah.
And was that police officer in uniform?
Yeah.
He had a badge on and a firearm and everything. You clearly knew he was a police officer,
Yeah.
correct? And that officer was, to the best of your knowledge, conducting a criminal investigation. Is that correct?
Yes.
And that criminal investigation, that was for a criminal investigation for taking your vehicle without your permission, or possibly joyriding with your vehicle. Is that correct?
Yes.
And you did make a statement to that police officer that you knew or should have known was false or misleading. Is that correct?
Yes.
And that was an issue regarding a material fact related to the investigation. Is that correct?
Yes.
And that statement in essence was that, is it Marquise, or Marquise, how do you say his name? Marquise Smith, stole your vehicle, is that correct?
Yeah.
But upon review of the police report and the documents involved in the investigation, that vehicle had actually been signed, you would actually sign the title of that vehicle to Marquise Smith, is that also correct?
Yes.
And, you knew that you would sign that vehicle to Marquise Smith, is that correct?
Yes.
Okay, and that you knew that vehicle was titled to Marquise Smith, is that also correct?
Yes.
So the time you made that statement to the police officer, you would agree that that was lying to a peace officer?
Yes.
And I know you may not know this, but to the best of your knowledge, the crime which you were making the statement to the police officer was involving joyriding, which is a 1 to 4 year possible sentence for that crime. Do you agree with that statement?
Yeah.
Okay. Judge, based on the amended information on the police report, I believe that's a factual basis that is sufficient to cover the plea.
I would agree, Your Honor.
Okay, thank you. Has the court complied with MCR 6.302 B, C, and D? Mr. McCready?
Yes.
Mr. Noe?
It has, Your Honor.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Coles has had knowledge of her rights and she has had competent counsel. Other than as we discussed on the record here this morning, the court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. We will set sentencing for July 20th at 8:15 a.m. Ms. Cole, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
Oh, I'm sorry, this is a misdemeanor. So you will need to get in touch with Mike McCarron in the district court probation office. That's on the first floor. You need to report to him this coming Tuesday. That's going to be June 20th at 8 a.m.
Okay.
All right, Mr. Noe, anything else we need to address in this case today?
Like you said, you should report to Mike McCarron on the June the 20th at 8 a.m.
June 20th at 8 a.m. Yes.
Okay, all right. No, nothing further on this matter, Judge. Again, I am ready on my other matter. Mr. Vasquez, when the court is ready, he's in custody.
Mr. Sala, are you ready to proceed with Mr. Cecil?
I am, Your Honor. Thank you.
Oh, never mind. They do it, they did it themselves.
Okay, we are on the record in file 22-21085-FC, People versus Andrew Aaron Cecil. We are here today for a pretrial conference. We are proceeding both in person and by Zoom. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Dan Saul on behalf of Mr. Cecil.
All right, Mr. Sala, where do we stand with Mr. Cecil's case today?
Obviously, this is set for a pretrial. I'm going to need to add a couple of probably 3 or 4 witnesses, and we're waiting for the transcript to be drafted from the prior trial.
Ms. Wise, anything to address from the people's standpoint?
No, Your Honor.
Is there any reason not to set this for trial at this time?
No, I just don't know how long the transcripts are going to take. I know everybody's kind of backed up doing transcripts, so the only issue would be once the transcript's ready. So I don't see any issue setting it for trial and then addressing that issue later.
We're likely looking at late September or October for a trial date, and just based on the length of time, I think we're going to need. That's likely what we're looking at.
Okay.
How many days, Ms. Wise, do you think we will need for trial?
I would guess a full week.
A full week meeting just for the people to present their evidence, or does that include what you estimate defense to be as well?
I'm guessing the people are gonna take 4 days, so I don't know, maybe Mr. Sala's gonna take 2, I don't know if he's gonna take more than 1 day.
Mr. Sala, having heard the people intend to use about 4 days for their evidence, do you have a understanding of how much time you are going to need, or how many days we should schedule for trial?
I would estimate that I'm going to need 2 to 3 days. So you're looking at a week and a half to 2 weeks.
Ms. McGrain, could you find us? Sounds like we will need, let's go with 8 days for a jury trial.
So our first available that's clear for that long would start on Tuesday, October 24th. We would do Tuesday, Wednesday, Thursday, Friday of that week, and Tuesday, Wednesday, Thursday, Friday of the following week.
Those dates would work for me, Your Honor.
The only day I have a problem with that is Thursday, the 26th.
So Ms. McGrain, can we look at the week of the 30th and then the week of November 6th?
Yeah, so we could start the 31st. However, the following week, that Friday is Veterans Day. So we would only have 7 days unless you started on that Monday.
Okay, so let's look at if there isn't anything scheduled on the Monday, or if there's not much that we'd have to move, let's use that Monday.
Yeah, we could do that. The health department case is scheduled for trial, but it sounds like that's not gonna go, so we should be good to do that. They already took that Monday, so you don't have anything else.
Okay. So that then would be October 31st through November 9th.
That would work for me.
That works for the people as well.
That begin at 9 a.m. on a Monday, 10 a.m.
9 a.m. on every day except Wednesdays, which would be 10:30.
Thank you.
Will the court be issuing a new scheduling order for that case?
Yes. And let's do a final pretrial then. On October 18th.
That'll work for me.
All right. Is there anything else we need to address today?
8:15, 8:15 a.m. for the pretrial.
Correct.
Thank you. Nothing further.
We're all set then, Mr. Cecil. You can let the officer that's with you know that you are done with court for today.
Can I talk to you for a second?
He wants a breakout room, Your Honor, if I may.
All right, Ms. Wise and Mr. Glazier on David Taylor. I just flipped through the files. I don't see writs for Mr. Taylor from Hillsdale today, if that's still where he is, or is.
He is, but we don't usually do a writ because he's our prisoner. Let me text Hillsdale Jail.
Okay.
Your Honor, is it okay if I go over to Judge Anzalone's and come back?
Yeah, that's fine.
Thank you.
All right, Mr. Glazer, do you need a breakout session with Mr. Vasquez?
I don't
I'm
represent.
sorry, I'm sorry, Mr. Noe.
Please, Judge.
Hey, Juan, you're over here.
Hey, Sharon.
Oh, looks like they're taking him.
Yeah, and well, right?
Well, they are, all of them are right.
Oh, they are, okay. Okay.
How about that?
All right, Mr. Vasquez, I'm going to put you on a breakout with Mr. Noe.
Okay, thank you.
I know.
It looks like they're getting Mr. Taylor and logging him in right now, Your Honor.
Okay, thank you. Mr. Glazer, you're going to need a breakout session with Mr. Taylor when he gets here.
Yeah, just to give him some dates. When are we gonna do this, the pre-trial, Sharon? I want to just explain to him what's going on.
John, I'm thinking mid-November if that works.
Okay, we don't have a date yet.
Yes, we have our trial date on.
I got those, so, okay, I'll explain to him.
Okay.
Mr. Jenkins, are you able to hear me?
Yes.
All right, I just want you to be aware we're waiting for your attorney to get logged in, so I'm gonna put you back in the waiting room. I just didn't want you to think that we I hadn't forgotten about you. As soon as your attorney gets here, we'll bring you in and get your hearing started.
All right, thank you.
Yep, thanks. All right, Mr. Noy, are you ready to proceed with Mr. Vasquez?
I certainly am. Thank you.
We are on the record in file 19-19465-FC and 19-19467-FC. People versus Juan Antonio Vasquez. We are here today for pretrial conference, and we are proceeding today both in person and by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Wise.
Morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Charles Noe on behalf of Mr. Vasquez.
All right, where do we stand with this case today?
Judge, on this matter, my client would want to have this matter set for pretrial. I'm looking at mid to late November. We can get a pretrial date, maybe set for November 15th at 8:15, and I'll coordinate that. He also has another pretrial in front of Judge. He also has a matter in front of Judge Anzalone as well. I'll be communicating with their office. I don't need to go on the record on that, but I'll communicate with their office to get the same pretrial on the same date, because there's some things that have to happen without going into detail on the record. That be done before this matter can be finalized. So unless Ms. White has an objection to that, that would be my suggestion this morning.
No, Your Honor, the people agree.
All right. So we'll adjourn this to November 15th at 8:15 a.m. Ms. Wise, do you want to have your office handle the stipulation and works for those files?
Yes, Your Honor.
Okay.
That would be fine. And Ms. Wise, you can sign that on my permission, please.
Great, thank you.
All right. Anything else to address today?
Ms.
No.
Wise, I'll shoot an email to Becky over at Judge Anzalone's office to make sure that date's okay with everybody else. CC you on that. I don't anticipate a problem that in November, but if there is, we'll coordinate dates with this court and Judge Anzalone's court. If we have to coordinate dates or change that date.
Okay, thank you.
Yeah, nothing further than Judge. Thank you. And
Thank you very much then.
you can tell them that you don't need to go in front of Judge Anzalone. Okay, you're all set.
All right, thank you.
Yeah, thank you.
All right. Good morning, sir. You're Mr. Taylor?
Yes, sir.
All right, Mr. Taylor, I'm going to put you in a breakout room with Mr. Glazier.
Okay.
All right, sorry, not what happened there. Let me move you to that breakout room now. Yeah, sorry, Mr. Glazer, we're having a bit of a technical issue. Let me start from scratch here.
All right.
I know I'm not make myself like from Second minute is ready to work. So. What is that? What are they saying? Not whole time, no? You don't wait. You don't wait. Well, no more. Why? Funny thing. We do whatever we get back, yeah, we there. Get paid $8 an hour, yeah, I wouldn't be gonna leave it.
All right, Mr. Glazer, are you ready to proceed with Mr. Taylor?
Yes, Your Honor.
Okay, we are on the record in file 19-19313-FH, 19-19314-FH, 19-19315-FC, 19-19367-FC, and 19-19433-FC. People versus David Curtis Taylor. We are here for pretrial conferences in each of those files. We are proceeding today, both in person and by video conference. First, let me ask you attorneys to place their appearances on the record. Please, Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
John Glazer on behalf of Mr. Taylor.
All right, and Mr. Glazer, where do we stand with Mr. Taylor's case today?
It's my understanding we're going to have a pretrial after the Cecil trial is my understanding.
All right, Ms. Wise, anything else to address with Mr. Taylor's cases today?
No, Mr. Glazer, we set Mr. Vasquez for November 15th. Does that date work for you?
That's fine.
All right, so we will set a pretrial in each of these cases for November 15th at 8:15 a.m. Is there anything else we need to address today, Mr. Glazer?
No, Your Honor.
Ms. Wise?
No, Your Honor, I'll prepare the stiff in order. Mr. Glazer, can I sign that for you?
Yes, that's fine. Thank you.
All right, thank you very much then. Mr. Taylor, you can let the officer that's with you know that you're done with court for today.
Thank you. That's all I have with you, Your Honor. We'll see you later.
Okay, thank you, Mr. Glazer. Okay, we're in a holding pattern until we get either Mr. Sala or Mr. Miller.
So I get for. So I get for.
May I approach?
Sure.
Thank you. You gotta open the player before you can add the videos.
My brother's wife. My daughter, my daughter. I don't know anything about my violation. My violation was into that. I know I didn't get to smoke marijuana, but it was a pretty no contact. That's really important.
Good morning, Ms. Underwood. You're here for Mr. Carver.
Yes, Your Honor, but I don't have any documentation.
He has a request and summons for probation violation. He's not present. Have you had any communication with him?
I don't have any documentation at all that I'm seeing.
We're sending it to you right now.
Okay, thank you. And he's not incarcerated, Your Honor?
No, he is not.
Okay. I have no knowledge as to Mr. Carver's whereabouts, Your Honor.
Okay. You're on the record in file 23-21275-FH, People versus Matthew Lewis Carver. This is before the court today on an order, a summons for a probation violation. Mr. Carver was ordered to appear here this morning at 8:15 a.m. It is now 9:27 a.m. Mr. Carver is not present in the courtroom, nor is he logged into the Zoom session. Based on his failure to appear, I am going to issue a bench warrant for his arrest for that failure to appear, and I will set bond on the bench warrant in the amount of $25,000.
Would the court consider a 48-hour hold on that bench warrant, Your Honor, to give us a chance to try to reach out to Mr. Carver?
This is a request and summons for probation violation. And so he's not entitled to the 48-hour grace period on that. So he's already, alleged in the violation, to fail to report to his probation officer. So I'm not willing to extend the grace period at this point.
Thank you, Your Honor.
Thank you.
Have a good day.
Thank you, you too. I emailed the jail and asked for Mr. McKenzie, so as soon as he is here, we can proceed with that case.
look at how much money we're spending on doing it all fucking stuff. Yeah. I got lucky for the other.
Mr. Saul, are you ready to proceed with Mr. McKenzie?
I can't do that in person. That'd be quick.
We are on the record in file 21-20677-FC and 23-2134-FH, People versus Casey Michael McKenzie. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference and in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. McCready.
Morning, Your Honor. Dave McCready for the people, standing in for APA PD.
Stand solemn on behalf of the defendant, Malik Owens, Your Honor.
Right, Mr. Sala, where do we stand with Mr. McKenzie's cases today?
At this point in time, Your Honor, we filed a motion to quash on one of the files, which was 23-21324-FH. And it's scheduled initially scheduled for June 30th, but I've had email communication with Ms. Meir, who's on vacation, so she wants to move that. So we would ask for another pretrial after that motion. So we would have to reschedule the motion and reschedule the pretrial.
You need to move the motion hearing, and then you want a pretrial after the motion hearing.
Correct.
What was the date of the motion hearing?
June 30th. She's gone until I think July 7th.
How much time do you need to argue that motion?
Probably just an hour at most.
An hour?
Half an hour. Probably half.
I guess since we don't have Ms. Meir here, it probably doesn't make sense to try to pick something arbitrarily, so.
I do have her calendar,
Oh, you
Your
do?
Honor.
Okay. All right, Ms. McGrain, are you there?
Yes, Judge.
Okay, so we're gonna need a half-hour period of time to have a motion hearing
How far out did we want to adjourn that?
sometime after July 7th.
You could do Tuesday, July 18th at 8:30.
That would mean. I'm checking.
That appears to be good for the prosecution as well.
Was that 2:30, she said?
Correct. We'll set it for July 18 at 2:30 p.m. And why don't we just conduct a pretrial on the same date and figure out where things stand after the motion hearing.
Judge, that was 8:30 a.m.
Oh, I'm sorry. July 18th at 8:30 a.m.
Is there any way I could address bond again today? I couldn't post bond.
that it was set at. I couldn't find a co-signer.
Just give us a moment, Mr. McKenzie.
All right, thank you.
That was one question I had here on the regards to potential tether in this case. I feel pretty confident on this motion as well.
All the way down, Ron. Three.
So Mr. McKenzie's bond at the moment is $4,000 cash or surety. Mr. Saul, what is it you'd like to say about that?
I would ask that he be allowed to go on a PR with a tether. If that's a possibility, so we can keep him on a tether. So basically we'll keep track of him, but he can't afford the $4,000 bond or even 10% of that at this point. So it's basically financial difficulty on his behalf. I assume he'll be able to pay the cost of the tether monthly, which I think is $300 or $400.
Would there be any way, I got $280 right now. Would there be any way I could pay it within 72 hours of release or no? That, I think it's a little bit short.
All right, let me hear from Mr. McCready first. Mr. McCready.
Well, Your Honor, as you know, I'm standing in for Ms. Muir, and I was not prepared to address the substantive issue of bond this morning.
I would note it's not a real high bond at this point, Your Honor.
I would agree. It's not a high bond, which suggests to me, given the charges that he faces and the fact that he also has a probation violation for failing to report that's pending before the court, that it seems to me that bond is reasonably set in this case. There doesn't appear to be at this point any additional information with respect to the relevant bond factors, so I'm going to deny the motion to modify bond.
I just don't get why it keeps getting pushed back with Phoebe Mears' problem. I'm not understanding this. I don't believe that's fair at all. I'm going to get out of jail when my motion's filed because I was legal shit happened to me. So when the 18th or 14th comes, you push it back again. What do I do? Sit in this motherfucker again? I'm not understanding this.
Mr. McKenzie, if you use language like that again, I will hold you in contempt.
Okay, I'm sorry. I'm sorry.
For you to address for the next 90 days or so. I've made my decision. You can let the officer know you're done.
Doing, Casey?
Mr. Sal, can you do a stiffing order for those, the adjournment of both of those dates?
Yes. So if I can sign Mr.
That's
McCready's name.
what yes.
Mr. Sal, are you ready to proceed with Mr. Owens?
I am, Your Honor, and we'd like a bench conference regarding the case.
Mr. Owens, I'm going to place you in the waiting room for just a moment. Just stay where you are, okay?
Okay.
Okay, we are on the record in People versus Malik Antonio Owens, file 20-19882-FH and 22-20974-FC. We're here today for pretrial conferences in both of those cases. The 20 file is here for probation violation. The 22 file is pretrial and new charges. We are proceeding today both in person and by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. David McCready for the people.
Stan Sal on behalf of Malik Owens, Your Honor. Thank you.
And we have had a bench conference. I believe there is a resolution worked out. Mr. Sala, do you want to state the terms of that resolution? I'll ask Mr. McCready to confirm.
Thank you, Your Honor. May it please the court. I have an agreement with the prosecution, and the court has indicated it would agree as well at this point for a plea to armed robbery using a guideline score that the prosecution and I, Mr. McCready, have agreed upon, which is a guideline minimum range of 51 to 85 months. But the agreement is he would be sentenced to the 51 months, the minimum on the minimum range, and of course the max would be up to 20, but he would be given a sentence consistent with the sentencing guidelines that the prosecution and I have set forth, and I have a copy of that if the court would like it. The probation violation as well, he would plead guilty to that, and it would run concurrent with the plea to armed robbery, and we would base the factual record for a potential weapon on the fact that he had fingernails that were exceptionally long, and in fact had minor injuries to the victim. So that's the agreement that we're going to, and as I indicated, I have a copy of the sentencing guidelines that I made a couple of changes on that Mr. McCready agreed with. The court would like that at this point to remind it when it comes time for sentencing.
I don't think I need that at this point. It would be helpful, I think, if you gave that to the probation office or the probation officer that's going to be preparing the pre-sentence investigation report. Mr. McCready, is that a complete and accurate statement of the plea agreement?
Well, I'll just make the clarification that the people are not agreeing to a bottom of the guideline sentence. We are agreeing to any sentence within the guidelines with no objection to the bottom. The defense has asked for copies from the court as to where it would sentence within the guidelines, but with that clarification, yes, what counsel's representative is accurate.
Okay, yes.
My apologies. That's
so yeah. So that is accurate. And my understanding would be the agreement of the people is, as Mr. McCready indicated, but also there is a comps agreement that the court would sentence at the low end of the guidelines for the 51 month minimum sentence. And I believe there was also an agreement to 20 years as the top end of the sentence, since it is the felon, it's a life or any term of years is the maximum sentence.
Don't agree.
Yes, sir.
All right. Mr. Owens, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Malik Owens, correct?
Yes.
Mr. Owens, you've heard the statement of your attorney and the prosecuting attorney, as well as my own statements. Is it your intention to plead guilty today to count 1 armed robbery?
Yes.
Are you satisfied with Mr. Sala and the advice that he's giving you?
Yes.
You can put your hand out if you like. You can. Do you understand that the maximum penalty under the statute for this offense would be life in prison?
Yes.
Other than as we've discussed on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf is discussed. Correct, Mr. McCready?
Correct, Your Honor.
Mr. Salah?
Yes, Your Honor.
Is that also your understanding, Mr. Owens?
I didn't hear you. What'd you say?
Other than as we've discussed it on the record here today, neither the prosecutor, the defendant, or yourself, or anyone acting on your behalf has discussed a possible sentence with me.
Yeah, right.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have a right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Owens, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
All right.
If you are not a citizen of the United States of America, a conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about June 15, 2022, in the city of Adrian, county of Lenawee, you did commit the offense of armed robbery?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you will be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea?
I understand.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Owens to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Owens, other than as we've discussed on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yeah.
Mr. Salah, would you like to establish the factual basis?
I would, thank you, Your Honor. Mr. Owens, on the date that the court's indicated to you, you were involved with calling for a ride. Was it Uber or Adrian Taxi?
It was Jeff Rice.
Okay, it was, I'm sorry, I didn't hear you. It was what?
Jeff Rides.
So it was a taxi?
Yeah.
It's called Jeff's. I believe he said Jeff's Rides.
Jack's ride? Jeff's ride.
Correct.
Okay. And it was a type of taxi service, correct?
Right.
You had to pay for the ride.
Right.
And after you had gotten dropped off in Adrian at the location where you asked the driver to take you, you asked the driver for change for a $100 bill?
Yes.
And when the driver brought money out of her pocket to give you the change, you grabbed the money from her hand?
Yes.
And your hand has long, sharp fingernails, correct?
Yes, sir.
And those fingernails could potentially be a weapon. Yeah. And you in fact scratched your fingers when you grabbed for the funds from her hand.
Yes.
And you took the funds.
Huh?
Approximately how much money did you take from her?
I took about $100.
And did you run?
Yeah, I ran home.
Okay, and did you have permission to take that $100?
No,
So you knew you were taking it without permission?
yeah.
Thank you. I have nothing further.
Mr. McCready, are the people satisfied with the action, please? Has court complied with MCR 6.302 B, C, and D? Mr.
Yes.
Ursel.
Yes, sir.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Owens said full knowledge of his rights. He had competent counsel. We'll refer this matter to the probation department and set sentencing for July 20th at 8:15 a.m. Mr. Owens, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Your Honor, you want to plead the probation violation today as well?
Yeah. Okay, and then with respect to file 20-19882-FH, Mr. Owens, you had the pending violation of probation for the same activity. So do you understand, Mr. Owens, that as with the other case, you would have a right to a trial with respect to the probation violation?
Yes.
You understand that with respect to the probation violation trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes. Yeah.
You understand that you would have all of the rights that I previously described to you would also apply with respect to your probation violation?
Yes.
How do you plead to the charge that you violated your probation?
Guilty.
And you understand by pleading guilty, you're giving up your right to have a trial on the probation violation?
Right.
Has anything been promised to you in order to get you to plead guilty to the probation violation other than the plea agreement that's been worked out?
No.
Has anyone threatened you in any way in order to get you to plead guilty to the probation violation?
No.
Again, if I accept that plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Right.
So your own choice to plead guilty to the probation violation?
Yes.
You were placed on probation back in January of 2021, correct?
Yes.
And one of the terms of your probation was that you not engage in any further criminal behavior. Is that right?
Yes.
And you would agree that you just pled guilty a few moments ago to armed robbery. Is that right?
Yes.
All right, I will accept that plea then. It's been given understandably, voluntarily, and accurately. Mr. Owens has had full knowledge of his rights. He's had competent counsel. Set sentencing on that for also July 20th at 8:15 a.m. And we'll refer the matter to the probation department for an update of the pre-sentence investigation in that file.
Thank you, and I would only indicate that, and I don't know, I think we put this on the record already, but I just wanted to make sure in regards to the violation of probation, it's another COBS agreement. The court would not exceed 51 months on the minimum of that, and it would run concurrent. I think we did already place it on the record.
We did have that conversation, I think, off the record.
Correct. The court has agreed in file 20-19882-FH that it would not exceed essentially the sentence in the 22 file, so it would not exceed 51 months as the minimum sentence. The maximum sentence in that case is 10 years, so it couldn't possibly exceed the maximum sentence. And or has to be, those sentences would run concurrent. All right, anything else to address today?
No, you're right. Thank you.
Not that.
All right, Mr. Owens, you are all set. You can let the officer know that you are done with court for today.
All right. Thank you.
Thanks. I like.
Yeah, Craig's in that.
Ditto. Oh, I'm sorry, I didn't see it.
Yeah, and,
All right, so. We need Mr. Valero for anything else.
We're all black, okay, $45. $3 black.
Yes, Your Honor. First of all, I'm not going to challenge the statement to the serious effect that this, my client's actions allegedly down the victim and his family. That's probably more appropriate for the court to consider the time of sentencing if the defendant is convicted. So Mr. Steve did make one statement of fact, which is not true. In the initial statement, the victim made the dispute, there was no mention. This is original charges just established. Because in the initial statement, the dispute talked about, as this is described, placing the on the bus. In the second statement, the defendant came after the matter started. He told the police, I believe it was the police in the place that as this unit is coming out of her camp, one of his fingers went within her body. So there was no evidence that was inserted his finger into her body. That's number one. Number two, there's no real what's going on with that. The second one is no claim that at any point did anything violate their body. Regarding alcohol, with regard to drugs, with regard to the contact of communication with other members. So I think my client proved that he was not a victim, that he was not a victim. And again, not to minimize the point who cases regarding the effect that these cases have on other people. That's more appropriate to the court to consider at the time of sentence.
All right, well, I'm going to deny, obviously, for that he has not gotten convicted, but he is going to be Thank you.
Yeah. Yeah. I would use that on that. Okay. So then
Thanks, Sam's coming in.
Oh, wait, there he is now.
Okay, and, okay. Yeah, yeah, yeah.
Okay, Mr. Malero, Dakota Jenkins is logged in.
Okay,
You
Judge,
need a breakout session with him?
I do not.
Okay, we are on the record in People versus Dakota Jenkins, file 22-21198-FC. Today is the date set for a pretrial conference in this case. We are proceeding today by video, well, in person and also by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hart.
Thank you, Your Honor. Doug Hart, I'm appearing for the people today.
Salvatore Malero on behalf of Dakota Jenkins.
And Mr. Malero, where do we stand with Mr. Jenkins' case today?
Jen, I've spoken to Mr. Hartung about this briefly, and due to, I think, a co-defendant's case being set for trial, we're asking to adjourn this.
All right, Mr. Hartung.
Your Honor, the case that Mr. Malaro refers to is the Zach Rosenberg case. It is in Judge Ansell's court. It is set for trial in early November, along the same time as that Cecil case. It was my case, and I'll have that reassigned to somebody else. But Mr. Jenkins has cooperated in that, and we would ask for this matter to be adjourned if Mr. Malaro agrees till after that hearing, sometime in that mid-November area.
Yeah, we have no objection.
All right. All right, how about November 15th at 8:15?
That's fine.
Judge, that's opening day, is it not?
I have no idea.
Well, okay, I'll do it anyways. Fine, November 15th.
I mean, we can go to the next week, would be the 22nd if,
Oh, that's worse. No, the 15th fine.
okay. All right, so we'll adjourn this then to November 15th at 8:15 a.m. Mr. Hartung, will you be willing to do a step in order for that adjournment?
Yes, we'll do that, Your Honor. Thank you.
All right, so Mr. Jenkins, your next date is November 15th at 8:15 a.m. For this case, you'll need to log back in by Zoom or be here in person for that.
All right, thank you.
Thank you, Your Honor.
Okay, and the gentleman at the jail, you are Mr. Young?
Yes.
Mr. Malero, do you need a breakout session with Mr. Young?
Briefly, Judge.
1 second.
Am I okay to log out?
Yes, you can go ahead and log out, Mr. Jenkins.
Okay, thank you.
All right, we are on the record in People versus Eric Michael Young, file 23-21305-FH and 23-21306-FC. We are here today for a pretrial conference in both of these cases. We are proceeding today, both in person and by video conference. First, let me ask the attorney to place their appearance on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people today.
Salvatore Malero on behalf of Eric Young.
Just for the record, Mr. Hartung is in person, Mr. Malero and Mr. Young are by video conference. Mr. Malero, where do we stand with Mr. Young's case today?
Your Honor, we ordered a transcript of the prelim and just waiting to get that. Pretty sure we don't have it yet. I think it was ordered about a month ago, or we got confirmation that it was ordered.
I've got transcripts in both files.
Oh, I don't have them, but I'll check if I have them. Then I anticipate preparing a motion based on those and filing them in short order. So if we could adjourn this, perhaps for 3-4 weeks, I'll get those motions filed. And I'm going to meet Mr. Young next week to discuss things.
Sir,
I have no objection to that. Just so record, I haven't received transcripts either yet, but I'm sure they're on their way to us.
Judge, you know what date you received those transcripts?
So mine is file stamped May 23rd.
The transcripts?
Correct.
Oh, okay. All right, I'll track it down.
Yeah, I'll see if we can figure out anything on our end too. So I'm sorry, you said how long, Mr. Malero?
Well, since they're already prepared, yeah, 3-4 weeks should be fine.
About July 19th at 8:15 a.m.
Yeah, that should be fine, Judge.
All right, Mr. Malero, would you be willing to do that step in order?
I would be.
Anything else we need to address today?
No, Your Honor.
No, Your Honor.
All right, Mr. Young, you can let the officer that's with you know that you are done with court for today. Mr. Hartung, do you happen to know who's covering Marquise Hernandez?
Judge, that's Mr. McCready.
Oh, all right. Thank you, Mr. Malero.
Yep.
Mr. Malero, is Kyle Choate with you, or do you know where he is?
Should be in jail.
Oh, he's in
Unless he
jail.
made bond. Let me look. I don't, maybe he did make bond. Let me look. I think he waived his exam, right? Didn't he waive his exam?
All right, we're calling the jail right now. He wasn't on the
Judge,
jail
I
list.
didn't do the exam. I think he waived in there.
Yeah, it looks like he did.
No notes, so I can't tell you what happened. I know his bond got reduced. I don't know if he made bond.
Do you have Kyle Choate out there?
Judge, can I ask a question? Did Issa Thomas get nollied as far as you know?
Thank you.
Yes, there was a nollie pros for all charges in the file.
Great, thank you, Judge.
Yes, sir.
Okay, Mr. Choate is at the jail. They are getting him now.
Yeah, I don't see him on the jail list, but he isn't, at least I knew he was.
Okay, Mr. Malero, do you need a breakout session with Mr. Joe?
Yeah, real quick, Judge, shouldn't take long.
Here. You call the prosecutor's office, we still need a prosecutor for this case.
We need a prosecutor for arraignment. We don't have anybody. It's Kelly and Judge O'Savers. Can you hear me? Can you hear me? This is Kelly and Judge O'Savers. Can you hear me? Kim, can you hear me? Girls. Francis, this is Kelly in the courtroom. Can you hear me? Okay, so it must be Kim's phone issue. Would you be able to call Kim at 4605 and let her know we need a prosecutor for Mr. Choate and Mr. Hernandez? Yes, please. Thank you. Bye. This is Kelly. Can you hear me?
Okay, we are on the record in file 23-21381-FH. People versus Kyle James Choate. We are here today for an arraignment in this case. We are proceeding today, both in person and by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Salvatore Malero for Kyle Choate.
All right, and for the record, Mr. McCready is in person in the courtroom. Mr. Valero and Mr. Choate are by video conference. Mr. Malero, does Mr. Choate wish to have the information read?
Your Honor, we would acknowledge you see the information. waive its reading as to counts 1, 2, 3, 4, 5, and habitual offender notice. We'd waive any defects of the time and place of service. We would acknowledge receipt of the witness list. My client would stay in mute, ask that a pretrial date be set, and ask that we be permitted to address the issue about it.
I will then enter a not guilty plea for Mr. Choate and set a pretrial conference for July 26th at 8:15 a.m. And Mr. Miller, you can proceed with your argument with respect to bond.
Thank you, Your Honor. Judge, we had bond down in the district court. Bond at that time was set at $12,500 cash or surety. I would just indicate to the court that Mr. Choate is a self-employed individual. He does have a minor child that he is responsible for support. He is a lifelong resident of the county. He does have some prior misdemeanors and felonies on his record. Mr. Choate is invested in getting these matters resolved in a favorable manner. So I think that his making himself available to the court when the court requires is something he's certain to do. Second, Judge, because he's a lifelong resident, I think him being considered a flight risk would be minimal. And with respect to the charges, even though some of these matters are serious, Judge, I would argue that they were a isolated incident in terms of the decisions he made, and that he does not pose a danger to society. Based on that, Judge, we'd ask the court to consider reducing the bond even further, perhaps even a personal recognizance bond with a GPS tether.
Mr. McCready, anything you would like to say in response to the request to modify the bond?
If I'm not mistaken, Your Honor, there's a 2-year mandatory felony firearm in this case. Is that correct?
That is correct.
So, I mean, that to me is one reason I would mention, if you say it's a mandatory 2 years, there's a flight risk just based on the nature of the charge. But other than that, I leave it at the court's discretion.
All right, with respect to the prior criminal record, what I can glean from the file at the moment is that Mr. Choate is charged as a habitual offender, 4th offense. He has convictions for delivery and manufacture of less than 50 grams of a controlled substance. Several of delivery and manufacture convictions. So 1, 2, 3. That would increase maximum penalty in these with respect to 5-year charges to life in prison. There's also the mandatory felony firearm charge that we have. Don't really have any information with respect to his record of appearance or non-appearance in past cases, or information with respect to substance abuse addiction, although I will say that prior felonies are delivery and manufacture, so certainly possession of some controlled substances with respect to that. Those cases haven't received any information with respect to mental condition or character or reputation for dangerousness. seriousness of the offense charged, it made reference that the habitual offender makes the penalties for this more serious. These are weapons charges, so possession of weapon by a felon, carrying a concealed weapon, and altering the serial number are among the charges. And when I was indicated that Mr. Choate is self-employed, he has been a lifelong member of or resident of Lenawee County. Based on all that, when I put all that information together, I think the bond to me looks reasonably set. Given the seriousness of the offenses and prior criminal history, I think there does need to be some bond here, and I think that the 12,500 cash or surety is a reasonable bond. So I'm going to deny the motion to reduce bond. Mr. Choate, you can let the officer that is with you know that you are done with court for today.
Thank you, Your Honor.
All right, Mr. McCready, are you handling Marquise Hernandez case?
I am, Your Honor.
Are you going to be trying that case?
Yes.
Okay.
Judge, could we do a bench conference with you prior to Mr. calling the case?
Yeah.
Yeah, give me a moment.